Welcome back. This is part 2 of our Listen and Learn series on leaseholds and real property. If you haven't watched part 1 yet, make sure to check it out first. We've covered all the essential concepts you'll need for this video. Now it is time to put that knowledge into action. In this video, we'll walk through a practical real-world exam scenario and practice the kind of legal analysis you'll need for exams and real property practice. By the end of this video, you'll be spotting issues like a pro. So, are you ready to flex those analytical muscles? Let's dive in and tackle a leasehold law hypothetical. This hypothetical is pulled from question 3 on the February 2023 California bar exam, but we've trimmed it a bit to focus on specific landlord-tenant issues. Tuan sells antique furniture. He signed a 10-year lease for a warehouse owned by Leo at $1,000 a month with a start date of January 1. The warehouse would be used to store Tuan's inventory. When Tuan attempted to occupy the warehouse on January 1st, he discovered Anika there pursuant to her validly executed lease, which was not due to end until January 31st. When Tuan returned to Leo's warehouse on February 1st, Anika told Tuan she was not leaving until May 31st. When Tuan visited the warehouse on June 1st, he discovered that Leo had stored equipment in the warehouse that made 25% of the space unusable. Tuan refused to take possession and informed Leo that he was terminating his lease immediately. Tuan never paid any rent to Leo. Tuan decided to sue for damages based on his rights under his lease with Leo. What claims, if any, may Tuan reasonably assert against Leo? So, what do we think? Does Tuan have any claims against Leo here? Leo is the landlord, so let's go through our landlord duties to see if Leo breached any of his obligations under his lease with Tuan. If you recall, landlords have a duty to deliver possession of the property to the tenant at the start of the lease term. Did that happen here? Let's walk through it. Tuan's lease began on January 1st, but when he arrived at the warehouse on that day, Anika was still lawfully occupying the premises because her lease did not expire until January 31st. Since Anika had a validly executed lease through January 31st, she had priority over Tuan. Therefore, Leo violated his duty to deliver possession of the property to Tuan on January 1st. We've established that Tuan has at least one claim against Leo so far. Do we think there are any others? Let's continue to go through our list of landlord obligations. Under this lease, Tuan is renting a warehouse to store inventory. So this is a commercial lease. That means the duty to repair and the warranty of habitability are not applicable here. But what about the covenant of quiet enjoyment? If you remember from our earlier discussion, the covenant of quiet enjoyment is implied in both residential and commercial leases. The covenant of quiet enjoyment can be breached when the landlord's actions result in either actual or constructive eviction. Let's consider actual eviction first. Actual eviction occurs when the tenant is denied possession of the premises. When the tenant is deprived in the entire property, they are not obligated to pay rent. However, when the landlord deprives the tenant of only a portion of the premises, the tenant's rental obligation is decreased proportionally. There are 2 periods of time we can consider for actual eviction here. The first is from January 1st to May 31st, while Anika was still in possession of the premises. Anika's lease gave her the right to possession from January 31st, and she then remained on the premises through May 31st. Tuan was therefore evicted from the entire premises through May 31st and may have a defense to paying rent for that entire period. We can also consider the period of June 1st through July 1st where Leo was storing equipment in 25% of the warehouse. In storing that equipment, his own equipment in the warehouse, Leo rendered 25% of the property unusable. Leo effectively took physical possession over that 25%, thus actually evicting Tuan from a portion of the property. Since Leo only occupied 25% of the premises, Tuan's rent obligation would be proportionally reduced by 25% for that period of time, but he would not be relieved of it altogether unless he could prove constructive eviction. So let's consider constructive eviction then. Would Leo's possession of the 25% of the warehouse space constitute constructive eviction and relieve Tuan of his obligation to pay rent entirely for that period? Remember, constructive eviction requires 3 conditions to be met. The first is that it is the landlord's actions interfering with the tenant's use and enjoyment of the property. Here, Leo is the landlord, and he is the one storing equipment in 25% of the warehouse. So that condition is clearly met. The second requirement is that the interference must be substantial. Tuan leased the warehouse to store his own inventory. Leo is using 1/4 of that space for his own equipment storage. That's a pretty large percentage of warehouse space that Leo is withholding from Tuan. So it's likely that this would be considered a substantial interference. Lastly, the tenant must vacate the property in order to claim constructive eviction. Here, Tuan never even moved into the property, so this condition is also met. Since Tuan has satisfied all 3 of the elements for a constructive eviction claim, he could likely claim Leo breached the covenant of quiet enjoyment. Hopefully, this hypothetical helped lend some context to how landlord-tenant issues can play out on the bar exam. Thanks for watching, and please subscribe so you don't miss any future content.